Judgment in the matter of Mills versus Mills.
Lord Wilson will explain the decision of the court.
When, following a divorce, it has to resolve financial issues which the husband and wife have not managed to resolve for themselves, the court wants, if possible, to split their capital in such a way as to achieve a clean break between them. In other words, to enable each of them to go forward without imposing any continuing financial obligation on one towards the other. Often, however, the court finds that their capital is not by itself large enough to enable each of them to live reasonably in the future, and that therefore a fair settlement has to include provision for continuing monthly payments by one to the other. In 2002, following their divorce, Mr. and Mrs. Mills were sensible enough to realize that their capital was not large enough to achieve a clean break. So, with their consent, the court ordered that, although Mrs. Mills should receive the majority of the proceeds of sale of their home, Mr. Mills should also make payments to her of £13,000 per year, payable monthly. The order provided for them to be made on the usual basis, namely until one or other of them died, or until Mrs. Mills remarried, or until the court made a further order to stop the payments or to alter their amount. An order of that sort therefore contemplates that the court can at any time stop the payments, which of course are still usually payable by a husband to a wife rather than the other way round. But the court won't stop the payments until the point has arrived at which the wife can adjust to the ending of them without undue hardship. The amount which Mrs. Mills received out of the proceeds of the home would have enabled her to buy a reasonable house free of mortgage. But she decided to take out a mortgage and to buy a much more expensive house. Then, for reasons unclear, she allowed the sum borrowed on that mortgage to increase dramatically. Then she sold that house and bought a flat. Then she sold the flat, and with a further massive mortgage, she bought a second one. Then she sold that one too, and by that stage she had lost half of what she had received out of the proceeds of the matrimonial home. Then, in the following 6 years, during which she rented 5 different properties, she spent the rest of it. In fairness to Mrs. Mills, it's important to stress that the loss of her capital wasn't as a result of wild living or extravagant speculation. It resulted simply from her entry into a series of ill-advised transactions. So, in 2015, having lost her capital and having earnings of her own of only about £19,000 a year, Mrs. Mills asked the court to increase Mr. Mills' payments to her of £13,000 a year, so as, in particular, to oblige him to pay an extra £4,000 a year in order to enable her to meet all of her rent, as well as her other modest expenses. The trial judge declined to do so on the basis that, in the capital settlement, Mr. Mills had already satisfied the need of Mrs. Mills for accommodation, and that he shouldn't have to fund the entire cost of her accommodation again. The Court of Appeal disagreed and ordered him to pay the extra £4,000 a year. There's no doubt that Mrs. Mills needed the extra £4,000 and that Mr. Mills could have afforded to pay it. But we have no doubt that the trial judge was right. There were 3 earlier cases in the Court of Appeal which had suggested that it wouldn't ordinarily be right to order a husband or wife to make increased monthly payments to cover a need which he or she had already adequately covered. Those earlier decisions are correct. We allow the appeal of Mr. Mills and restore the trial judge's order that his monthly payments to Mrs. Mills should continue only at the rate originally set in 2002.
Thank you. The court will now adjourn.